where to report, and the time.
Okay.
Okay?
Thank you.
So thank you very much. Have a great rest of the day.
You too.
Okay, Council, let's talk a little bit about the afternoon jurors. There's been there have been jurors that have requested postponement. Has 41, is he or she still on?
41 is postponed.
Okay, 41 is out. 43 is out. Is 44 still on?
44 is postponed.
Okay. So we'll start with 46, 47, 48.
47 is postponed as well.
Oh, okay, thank you. You're getting more up-to-date information than we are. Okay, so we'll start with 45, 48,
No, 46.
It's
46, 48,
51. 51, 52, 55, and then 57.
okay. All right, that's the afternoon. Okay, Council, have a great lunch, and we'll reconvene at 1:30.
Okay, and so with that, makes 10 jurors on this panel. We're looking to get 12 to hear the case, plus 2 alternates in the case that anybody drops out. We're getting in closer and closer to seeing whether or not this case is going to start on December 8th. As projected, we may have the jury by today. This case could start as early as tomorrow. Let me bring in our guest analyst to talk a little bit about what is ahead in this case. Still with me in Colorado, criminal defense attorney Jeffrey Wolf, and just joining us this hour in Pennsylvania, trial attorney Stuart Ryan. Great to see you both. Stuart, I'd like to begin with you, please, since you're just joining us this hour. In terms of what is ahead in this case for both sides, because they really got to be thinking about it, getting closer and closer to this jury being picked. Talk to me about what you see as the biggest challenges each side is facing going in.
Well, so first and foremost, I would say that, the biggest challenge that the government is going to face is being able to convince this jury that the defendant acted with the level of intent that they're going to need to prove, right? So what you have here are manslaughter charges that are going to require a certain level of intent. And there's crucial evidence, especially with regard to the body cam video, that I think really bolsters the case for the defendant. When she's yelling taser, 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 I would suggest that certainly what her attorneys are going to say to the jury is that you can look into her mind during those moments and know that she's not intending to act with any level of lethal force, but rather she made a fatal but a genuine mistake. When it comes to the defense side, I mean, an interesting thing that you saw happen before the trial, which was, I think almost unheard of typically, is that the defendant was colloquied on whether or not she would testify and committed to testifying. Assuming she follows through on that, really the crucial challenge for them is making sure that she's able to connect with the jury and convince them of exactly what it is that she needs to do, which is to demonstrate that she wasn't acting with the level of intent that the government claims.
A really great point, Stu. Thank you. Jeffrey Wolf, let me ask you, please, about who you think may have an advantage going in. In your view, does either side have an advantage at the start of this trial? And if so, why, please?
At the start of almost any trial, the prosecution has an advantage. They have the limitless resources of the government, in this case, the Attorney General's office, and that is a overwhelming advantage in almost every single case before any words are said. As far as the factual circumstances of the case and the climate in Minnesota right now while they're dealing with all of this, I think the advantage also goes to the prosecution here. We have multiple states of mind that are going in here on these manslaughter charges, namely reckless and negligent. So they have options there for the jury to consider as well. As a defense attorney, I often like to posit to a jury that if they need options, they don't know what happened. If they don't know what happened, it's not beyond a reasonable doubt. But I think that most prosecutors would say it's an advantage to be able to give the jury options and have them be able to make a compromise, which is, I think, what they're trying to do here to at least get a conviction in this case. And this is a climate in Minnesota that can't be discounted either. This is a state where they just saw a conviction, a murder conviction in the case of the George Floyd murder here. And so this is a state that is standing up and saying no more. And they're hoping that this jury will do that as well. And to say that an officer just gets to make a mistake and have somebody die is beyond the pale, in my opinion. I think this officer's fatal mistake is one that she should have to pay for, besides resigning her post. I think that this is somebody with over 20 years of experience as a police officer that can't tell the difference between a taser and a firearm, which are completely different weights, look completely different, feel completely different, and actually hang on opposite hips. So when your right hand goes down, you're taking your gun. When your left hand goes down, you're taking your taser in this case. And if you can't get that right after 20 plus years, you've committed a crime and you've killed somebody. And so I think that the state has a pretty strong case here.
And I think the prosecution, if they're smart, they're going to take a page out of your book, what you just did there, Jeffrey, that little sampling, great arguments they're going to make. Absolutely, if you're on the side of the state, you're going to talk about what an embarrassment, what a disgrace this was, that she made that kind of horrendous mistake on the job. You said something, Jeffrey, that made me think of another great question I want to pose to Stuart Ryan. And you talked about the climate there in Minnesota. And we've had a lot of really great spirited discussions here on Court TV about the effect that the climate surrounding the case can have on jurors. And we all know they cannot be influenced by the outside. And with that all being said, Stu, going into this case, do you think that the attorneys and the court ought to be thinking about sequestering this jury?
Well, it's a great question, and one that's really challenging, certainly, to tackle. Really, the most important thing when you're talking about sequestration is whether or not, even if these folks are going to be sequestered, exactly what that looks like. Meaning, are they going to have, for example, access to their cell phones? I've had cases where juries have been sequestered, but they've had access to their cell phones, and to me, that's no different than not. That's essentially not being sequestered at all. Now, I do think in terms of the social climate, that's something that is to be considered. But I don't know that it necessarily weighs directly in favor of sequestering this jury as much as whatever the publicity at this moment surrounding the case may be and the intensity of it in this particular area where we're dealing with. As much as the social climate, I think, can come into it, what I have seen so far in terms of jury selection is that both sides really are looking for rule followers. They're looking for people who are going to honor their commitment to listen to the evidence that's in front of them and follow the law in applying that to the evidence. That's certainly, I think, what we've seen here. And I don't know that the social climate in and of itself is going to warrant sequestration of the jury, which is an extreme step in most cases for judges to take.
Yeah, certainly a really tough issue, as you said, to tackle. Stuart Ryan, Jeffrey Wolf, thank you both for all of that great insight. We're going to squeeze in a quick break. When we come back, we're going to take a closer look at some of the jurors who've been selected to hear the case against Kim Potter. We're going to dissect some of their responses regarding previous interactions with law enforcement and talk about how that might play into how they view the evidence they receive. Thank you for being with us this Thursday here on Court TV Live. Thanks for being with us here on Court TV Live. I'm Julie Grant. So during the voir dire or the questioning of the prospective jurors to hear Kim Potter's case, they've been asked about their personal interactions with law enforcement, their experiences that they've had. And we know that that can affect how they view the evidence that they receive. And of course, they're the ones making the decision on the facts in this case. Let's take a look together now at some of their responses.
Now, you stated that a friend or family friend was a victim of a fatal stabbing in Minneapolis, and it was a close friend. Were the police called in connection with that?
Yes.
Did the culprit who did this, was he or she ever found?
Yes.
And what happened to?
He was found guilty.
Did you think that justice was done in that case?
Yes.
You can be fair and impartial in this case, even though your friend was murdered, right?
I believe so.
You also suffered, you were a victim of a crime. A car was broken into. Is it your car?
Yes, yes.
Okay, You were somewhat satisfied with the police? Did they solve the crime?
Yes.
Okay. They found the person?
Yes.
Were you pleased or at least satisfied with how that case was resolved?
Please.
Was that person charged, if you remember?
I believe so.
Police in my community make me feel safe, and you said you strongly agree with that. Why did you choose strongly agree?
Because that's the way I feel. I feel like they're there and they provide a purpose and they provide safety.
You stated that your friend's shop was broken into during one of the demonstrations and he had inventory stolen. Can you decide this case based upon the evidence and not have any sympathy or whatever concern for your friend without regard to that?
If I'm being 100% honest, I don't think it's my relationship with my friend and what happened to him that would decide my viewpoint on the case.
So I assume over your career, you have worked fairly closely with Minneapolis police officers.
In some situations, we always waited until they cleared the scene before we would go on the scene and stuff like that.
Over the course of a career, you've had a lot of good experiences with Minneapolis police officers.
Yep, yep. Everybody kind of does their own job.
You stated that you or your family have been victims of crimes. What was the reaction that they had to how the police handled the situation? Satisfied, not satisfied?
There's certain situations that they were satisfied, others that they weren't. Things that, like, you know, it's out of the officer's hands sometimes. It's just the law and what they can do, what they can enforce.
Have any of those interactions with police in those circumstances make you biased against police officers in general?
No. Like I said, I know that certain officers can be like that and others aren't.
Okay. Have you personally had any negative interactions with police?
No.
You were a victim of a crime when your apartment was broken into, correct?
Yes.
Did you report it to the police?
Yes, I did.
Okay. And were you satisfied, dissatisfied, or neutral on how they responded?
I would say neutral. Yeah. I mean, they responded. They were respectful. Nothing really came of it, I guess, but.
Okay. Anything about that makes you think you would be biased against police officers?
No.
Okay. You stated that your cousin was tased during an arrest. Anything about that makes you think you shouldn't be a juror in this case?
No.
Okay. Someone in your family were charged or accused or convicted of crimes. My question is, did you think that justice was done in those cases?
Yes.
Okay. Did your family ever indicate any dissatisfaction with the way the police handled the situation?
Not that I heard of, no. I think I was raised to trust police officers, but...
You still trust police officers?
I don't know. I try to,
that?
but I think just given... I mean, I would say police officers interactions with police officers in general make me nervous.
You said that I am slightly distrustful of cops. I believe they have an incredibly hard job, but I believe they should be held to the highest standard of scrutiny.
People are people, and I don't think that a badge should exclude you from consequences to actions potentially.
All right, so that was just a little glimpse of some of the answers that those jurors gave. Let me bring in our guests now for some analysis. Still with us in Pennsylvania, trial attorney Stuart Ryan, and in Colorado, criminal defense attorney Jeffrey Wolf. So first question to you both is just kind of what jumped out at you watching that? What were some of the thoughts going through your minds? Jeffrey, I'll start with you, if I may, please.
Yeah, what I was thinking about is how much the answers to those questions have changed in the last several years, because these are questions that we've been asking jurors for 20, 30, 40, 50 years. And usually what you got was a lot of, well, officers are here to protect us and they're the good guys, and usually you want to believe them. And so you would establish all these challenges for cause as a defense attorney because of the inherent trust in the police. Now you're hearing exactly the opposite. That used to be the minority opinion, that you would have 1 or 2 jurors that would be willing to say that kind of stuff, and the prosecution would be doing everything they can to get those people to be quiet and get them off the jury as quickly as they could before they poisoned the rest of the pool. But now what you're seeing is that the majority of jurors at least have a slight amount of distrust in the police and know that there are issues surrounding what the police do when they interact with the public. And that is heartening to me as a defense attorney, because I happen to know it's the truth. I've seen enough of these cases to know the way officers can act, and there are good officers out there. But what we have really learned over the last couple of years is that until good officers turn in bad officers, there are no good officers. And we see that more and more and more. And so it's nice to see a jury pool finally getting that.
Stuart, I want to ask you the same question as you were watching along to those answers. What jumped out in your mind, please?
Yeah, I would have to agree that I think what you're seeing here is the beginning of a sea change, similar to what we saw with regard to picking juries in sexual assault cases with the advent of the Me Too movement. And I was a prosecutor. I handled sexual abuse cases and saw over the course of my career from the beginning towards, when I was leaving that office, the way that the differences of opinion that you saw in jurors. And I think you're starting to see that follow behind by a couple years, that sort of sea change that you saw with regard to sexual assault cases. And where I think the danger really lies in this case for the defendant is when jurors are evaluating that and coming to these different opinions and different conclusions about the way they view police or trust police. This is not the Derek Chauvin case in the sense that was, I think, clearly an intentional murder. It occurred over several minutes. It was a gruesome video to look at. But what you have here, I think, really is what some are going to consider an abuse of authority at the outset of it, that this was a pretextual traffic stop. And people are going to look at that as an abuse of power, and it's going to start infecting the case and the way that the defendant, who in this case is the law enforcement officer, gets viewed from every step along the way after that. And those differing views that we see now with regard to how people view law enforcement, I think, are going to be problematic in that regard.
Ooh, I love that you honed in on that, Stu. And that's a great question. I'm going to hand this one to Jeffrey. Jeffrey, do you think if the state is smart here, they're going to hone in on what Stu just shared with us and try to argue this was a pretextual stop, and then argue that the use of force, even if she thought it was a taser, that was still too much?
Yeah, I do think they will do that if they were smart. They're going to lean in to the deodorizer hanging from the mirror as a reason to pull him over, and an expired tag as a reason to pull him over, and to get so aggressive in pushing for the arrest once they realize he has an outstanding warrant. All of that is perfectly legal, and it's been happening in our country for a very long time, where they'll pull you over for anything. And then once they realize you've got an arrest warrant, it goes from A to Z so quickly. And the problem for them here is that what you would like to see an officer do in that circumstance is explain the reason that somebody was pulled over calmly and professionally, and say, and just so you know, we were just made aware that you have a warrant. Please step out of the vehicle, and do it professionally and politely, instead of what you see all too often in this country, which is an extreme elevation, because they know exactly why they're pulling him over. They're not pulling him over because he's got an air freshener in his car and an expired plate. They're pulling him over because they ran the plate and saw the warrant. And so they go up ready for bear immediately. And often you're going to see people not be aware they have a warrant, or if they are, not knowing the officer knows that, and it just creates a problem. And so, yes, if the prosecution is smart, they're going to lean in to this type of interaction, and that it occurs, and it creates danger where none might otherwise exist.
We have that footage, and perhaps we can play it at some point later in the show to go over the chain of events and just how things unfolded. I can say it was fast, really fast. I mean, I've watched the video a number of times, and it really escalates quite quickly. I have to leave it there for now, but great insight from you both. We're going to squeeze in a break. When we come back, we're going to turn our attention to the Gilain Maxwell sex trafficking trial. This is a federal criminal case happening in New York City. The first of the 4 Jane Doe accusers. There are 4 Jane Does on this indictment, first of 4, and she was also the youngest of the 4 testified. The testimony went over 2 days' time. She was crossed by the defense, and we're going to break down how the defense team tried to cast doubt on her memories because at the time she says she was abused by Jeffrey Epstein and Gilain Maxwell. She was only 14 years old. Welcome back to Court TV Live. Thanks for staying with us. I'm Julie Grant. We're getting closer and closer to that jury being seated in the trial of former Minnesota police officer Kim Potter. Right now, there are 10 jurors who are seated. We're looking for just 2 more on the jury, plus 2 alternates, and then we'll see if the trial will begin any sooner than currently scheduled. Now, Potter is, of course, charged with the killing of 20-year-old Daunte Wright back in April after she mistakenly pulled her gun instead of her taser during a traffic stop. She's facing 2 manslaughter charges in both the first and the second degree. One is predicated on the reckless use and handling of a firearm. That's the first degree charge. The second degree charge is all about culpable negligence and creating an unreasonable risk. So we want to get the latest on the jury selection process now. Let's bring in Court TV legal correspondent Gilain Painter. Gilain, good afternoon.
Hey, good afternoon, Julie. So we just seated the 10th juror for this panel. We need, of course, 12 with 2 alternates, this latest juror. According to the pool reporter notes, remember, there's only a couple of reporters inside the courtroom watching jury selection. So we know juror number 40 is a white male in his 40s. He told this court that at one time he wanted to be a police officer, but later changed his mind, and he is juror now number 10 on this panel. But let's take a look back over the last couple of days of jury selection and who is going to hear this case. On day 1, we had juror number 2, a white man in his 50s. A medical editor made the panel. Juror number 6, a white woman in her 60s, a retired special education teacher. Juror number 7, a white man in his 20s, a department store manager and musician. And juror number 11, an Asian woman in her 40s. That was day 1. Day 2 on yesterday. These are the jurors who made the cut. Juror number 17, a white woman in her 20s, a recent college graduate. Juror number 19, a black woman in her 30s, a teacher. Juror number 21, a white man in his 40s. 22 is a white man in his 60s, a private nurse. And juror number 26, an Asian woman in her 20s. So now we have juror number 40 added to the mix. And again, prosecution's out of strikes. The defense still has 3 to use in this process. So we shall see if we have a jury today.
Right. Gilain, thank you so much. We're going to turn our attention now to the Gilain Maxwell case. We're in day number 4 of this federal trial. It's happening in New York City. She, of course, is accused of trafficking teenage girls for sex offender Jeffrey Epstein to abuse. The allegation is that the abuse occurred over a span of 10 years' time. And the first of the 4 Jane Doe accusers spent 2 days on the witness stand. Now, this alleged victim is being identified only under the pseudonym Jane, and she was aggressively questioned on cross-examination on Wednesday, even breaking down at some points in the questioning when Maxwell's defense attorney was asking her several questions that were trying to cast some doubt on her memory. In one of their exchanges, the defense attorney asked, quote, "As you sit here today, you don't remember if you and Ms. Maxwell and Mr. Epstein were ever in a room alone together?" And Jane replied, "No." And in another exchange, the defense attorney asked, quote, "2 years later, now you remember that Gilain called your home to make appointments?" Jane responded, "Right." Now, the defense attorney continued to press Jane, saying that, quote, "that memory has come back to you in the past 2 years," end quote. And she responded saying, quote, "memory is not linear." Okay, so this was just some of the questioning that took place. I want to bring in our guest to discuss. Still with us, trial attorney and former prosecutor of sex crimes, Stuart Ryan. He's joining us from Pennsylvania, and in Colorado, criminal defense attorney Jeffrey Wolf. Stu, I want to go to you first on this one, as this is certainly your wheelhouse. What do you think about what we were just relating about some of that questioning going to a witness's memory when we're talking about events that happened in the 90s? She was 14 at the time she was allegedly sexually abused. What do you say to anybody who says, how can this woman possibly remember what happened to her so many years ago?
Well, so I think first and foremost, when you're dealing in any sort of a trial, witnesses' memories, whether it's the victim or a bystander, whatever the case may be, are always going to be imperfect. I think as human beings, jurors understand that, and that's something that I think will get, they will be reminded of that over and over. As it relates to the ability to remember and specifically what you remember, I think where we have come from a scientific perspective over the years as it relates to the way trauma affects the brain and memory has made it a different ballgame when it comes to these sorts of cases. And I know they had an expert witness testify, I believe, as their first witness, which was a really smart move on the part of the government to sort of lay the foundation for some of the things that the jury is going to hear about. And eventually, what I think you end up being able to help jurors understand is that oftentimes trauma and sexual trauma being inflicted on anybody, but especially a child, can have serious impacts on the development of the brain and the way memory is received. That certain memories are going to be blocked out, they're going to be fragmented, things along those lines. So I think the more typical and traditional and old school lines of cross-examination as it relates to faulty memory are falling further and further by the wayside as a result of the developments in brain science and trauma.
Stu, thank you for all of that. Jeffrey Wolf, let me turn to you on something I think so many Americans have questions about, and that is why there wasn't a plea agreement struck up in this case. And with that being said, we all understand she is presumed innocent. She's cloaked in the presumption of innocence as she is sitting there today. And many who followed the case against Jeffrey Epstein have felt that if Gilain Maxwell has the opportunity, she's going to sing like a canary because she, as the prosecutors have said, was his number two. They've said she is his partner in crime, that she knows where the bodies are buried, so to speak. Can you give us some insight as to why there may not have been a deal offered, or accepted in this case?
Yeah, I think it's a pretty complex analysis in this specific case, because you're right. If Jeffrey Epstein was the one on trial, she would probably have been the state's star witness. But Jeffrey Epstein's never going to stand trial. Jeffrey Epstein is dead. He committed suicide in jail. And so there is a sense, I think, in the prosecution of this case that this is the justice that these victims can get, that this is the day in court that they can get. What I hear from prosecutors when they are talking plain with me about cases where they're not offering a deal is they often say the victim wants their day in court. They want to stand up in front of your client and point that finger. And so I think we're seeing a lot of that in this case particularly. Additionally, once the sweetheart testify against Epstein deal is off the table, what benefit is there to Maxwell to taking a deal if it involves prison time, the sullying of her reputation, and basically being the person that takes the fall for all of this? All of it. Because what we really see here is we see two people, one of whom is no longer with us, one of whom is standing trial, basically taking the blame for the rich and powerful of our country and other countries. They're taking the fall for all of it. They are, Prince Philip isn't on trial. Bill Clinton isn't on trial. Donald Trump isn't on trial. Any of the people tied to this, Bill Gates, the list goes on and on and on. None of them are on trial. None of them are having the finger pointed at them. So what benefit is there to the defense of taking a deal here? Because it would almost certainly come with prison time, and it would definitely come with being the one person held responsible for dozens and dozens and dozens of people's bad behavior. And so I just don't see a path forward to a deal in this case for either side for those reasons.
I understand what you're saying. And we want to put up the charges in this case on your screen so you can take a look at just some of them. There are 8 in total. There are some perjury charges as well, but we're talking about the procuring of minors, transporting them across state lines to engage in sexual activity. That's the overall overarching legal theory here of the federal government. Stu, you know this better than anybody. Sometimes when you're a prosecutor, you have to take to trial a case that you may not feel is the strongest case for any variety of reasons, but you have to do what you have to do. Tell me, looking at this case as objectively as possible, as someone like you can, how strong do you think the federal government's case is here against Gilain Maxwell?
I do think that it is strong. It's largely going to be built on witness testimony, but the strongest part of their case is the culpability of Epstein, because with dealing with these conspiracy charges, that's the perfect way for them to lay all of the misconduct, fair or unfair, that Epstein engaged in at the feet of Gilain Maxwell, and demonstrating that she was aware of it and she participated in it. She didn't withdraw from from it. And so I think in that sense, this is really the government's opportunity to try the case that they wanted to try, albeit against Maxwell alone and not the two of them together.
Sure. Jeffrey, a lot of people are wondering if Gilain Maxwell is going to take the stand and testify in her own defense. And I know you don't have a crystal ball, but if you would just give us your best educated guess on what you think we will see in this trial, please.
I cannot imagine that there would be a good reason for her to take the stand. What the defense attorneys are doing in this case is they're doing their best to attack the witnesses in front of them rather than say that she's going to get up on the stand and have some big revelation. The reality of the situation is if she's testifying under oath, she's likely to incriminate herself and others. And so I just can't imagine why it would happen from the attorney's perspective. Now, the thing that we always end up talking about when we talk about whether a defendant is going to testify is that it is actually the defendant's choice. It's no one else's. And the judge is going to let her know that, and her lawyers have let her know that, presumably. She has two really good lawyers from Colorado on her defense team, by the way. And they are going to absolutely make sure that she knows whether it's a good idea and that it is her choice. And so she could go against their advice and just decide it's her time to speak. But I cannot envision that anything good would come of that for her.
Jeffrey Wolf, Stuart Ryan, thank you both so very much. Time to squeeze in a break. When we come back, we're going to turn our attention to a case we've been reporting on since the outset, that deadly movie set shooting involving actor Alec Baldwin. Well, he's giving his first official interview with ABC News following that deadly shooting, and we're going to share with you some of the shocking revelations about what he says really occurred on that dreadful day. It's next. Thanks for being with us here on Court TV Live. I'm Julie Grant. New details to share with you now on the deadly on-set shooting involving actor Alec Baldwin. We're now hearing from Baldwin for the first time since that deadly incident on the set of his movie Rust. In an interview with ABC News, Baldwin said that he did not pull the trigger.
It wasn't in the script for the trigger to be pulled.
Well, the trigger wasn't pulled. I didn't pull the trigger.
So you never pulled the trigger?
No. I would never point a gun at anyone and pull a trigger at them, never.
What did you think happened? How did a real bullet get on that set?
I have no idea. Someone put a live bullet in a gun, a bullet that wasn't even supposed to be on the property.
Wow. You can hear the rest of Baldwin's interview tonight on ABC. And in the meantime, this is all coming as several new details are being uncovered in the investigation. We're learning that New Mexico investigators searched an Albuquerque prop shop where some of the rounds used on the film set were believed to have been purchased. In the search warrant, the Rust armor, Hannah Gutierrez Reed, said that she or the prop master picked up ammunition for the movie from a man named Seth Kenny at PDQ Arm and Prop. Now, according to the search warrant, investigators were looking for the following. They're looking for ammunition, whether it's live or spent, any and all boxes and or containers that may hold said items, any and all gun cleaning equipment. Ammunition must contain the Starline brass logo for evidentiary comparison. Now, following the search, Hannah Gutierrez released a statement saying in part, quote, "We trust that the FBI will now compare and analyze the live rounds seized from the set to evidence seized during the search warrant execution to conclusively determine where the live rounds came from," end quote. And, quote, "We also hope that there will be further investigation into the important detail about a new ammunition box seen on the set the day of the shooting. The questions of who introduced the live rounds onto the set and why are the central questions in this case," end quote. Woo. Let me bring in our guest, the analyst, to see what they think about this. Still with me, criminal defense attorney Jeffrey Wolf and trial attorney and former prosecutor Stuart Ryan. Boy, oh boy, all of this seems to raise even more questions, but just want to kind of get what's going through your mind, your general thoughts, hearing these new bits of information. Jeffrey, I'll begin with you, please.
Well, one of the things that really struck me when I saw that little snippet from the Alec Baldwin interview is how did a gun go off if nobody pulled the trigger? And it's almost like what he's alleging is that there was some sort of malfeasance with the gun itself, or that the gun was malfunctioning. I mean, I don't think anyone is talking about Alec Baldwin having a legal culpability here. It's not his job to know that there's a live round in that gun. That's not how movie sets work. We've all learned way more than we could have ever imagined we would learn about how this process works. And maybe the question now is, do we actually need guns on the sets of movies, given the technology that we have? I listened to an interview where George Clooney really broke this down about why this needs to be on the set and all of this sort of thing. And I just can't see it. If this is the risk, and there have been incidents in the past, this doesn't fall on Alec Baldwin. So why does he have to bring that up? I don't quite understand where he's coming from and why he's bringing that up, because I think if the gun fired, somebody pulled the trigger and the gun was in his hand. That was the part that was so strange to me.
I'm with you, Jeffrey. It just makes zero sense to me. Stu, I want you to weigh in on that same question. What do you think? Does it strike you as very odd what he's saying and kind of perplexing as then how it could have happened?
Yeah, well, when I hear things about this case, the first thing I think of is that it sounds like a humongous mess. And a lot of credit, hopefully, is going to have to go to the investigators dealing with this to try and unravel what's happening. Now, as it relates to what Alec Baldwin had to say, I tend to agree with what I've heard thus far, which is it is unclear how a gun discharges without someone pulling the trigger. I don't know if he's, as we heard, suggesting a malfunction or if he's suggesting it was some sort of accidental discharge. I understand he might have been practicing some sort of physical movements, if the movement, caused the gun to discharge. But, under almost any circumstances, I think it's suspect to say that he didn't pull the trigger, but the gun discharged. But look, that remains to be seen, and that's what investigators are doing. And the reason I say that I think it's a big mess and what's troubling for the investigators is you have witnesses issuing press releases and statements to the media after they've been interviewed by law enforcement or after search warrants have been executed. And that makes the job of law enforcement exceedingly more difficult to try and unravel this and get to the truth of the matter when every time they talk to somebody, they're issuing a press release to the media to say, here's what I said and here's my take on it. Here's what I think happened. It just makes their job a lot more difficult and could make it harder to get to the truth.
Oh, sure. And I can recall seeing some footage from paparazzi trying to follow Alec Baldwin in the days right after this occurred, trying to ask him for information. And he was saying that he was instructed by the sheriff's department not to talk to the media, telling the media, please understand. But I don't know what changed from now, or from then until now, with the interview he did, the sit-down interview with George Stephanopoulos. But certainly interested in hearing what he has to say. To Jeff's point earlier, I'm wondering if it's because of civil liability. I wonder if that is his concern because he was producing this film. And I can't remember how many suits have been filed to this juncture. I know we've seen some reporting. We could try to get that answer up perhaps during a break. We just have a couple of minutes left, so I'm going to play that 911 call now from the set of that movie, Rust. Let's go back to that day and listen.
Santa Fe Fire and EMS, what's the location of the emergency? Bonanza Creek Ranch has had 2 people accidentally shot on a movie set by a prop gun. We need help immediately. Okay. Bonanza Creek Ranch, come on.
Stay on the phone with me. We're going to get some help, okay?
Okay.
What is your name?
Mamie Mitchell. It sounds like somebody else is calling for 2 ambulances. You better make good. Everybody should be. We need some help. Our director and our camerawoman has been shot.
So was it loaded with a real bullet or one?
I cannot tell you that.
Okay.
We have 2 injuries from a movie gun shot.
Okay. We're getting them out there already. Just stay on the phone with me.
Thank you. Okay. I just that yelled at me at lunch because asking about revisions. You seen him lean over my shoulder and yell at me? He's supposed to check the guns. He's responsible for what happened in the company.
Now, Mimi?
No. I'm a script supervisor.
How many people are injured?
2 that I know of. I was sitting, we were rehearsing, and it went off, and I ran out. We all ran out. They were doubled over, the AD and the camera woman and the director. They're clearing the road for you to come back. We're back in the town. Take a call. We're back in the western town.
Is there any serious bleeding?
I don't know. I ran out of the building. But
that's fine. I still have to go through these, okay? Are they completely alert?
We don't know. I can't tell that.
Okay, we just have about a minute left. And Jeffrey Wolf, I know we're going to have to say goodbye to you at the top of the hour. So I want to go to you on this, please. You touched on it a bit. But for anybody wondering, if Alec Baldwin will face any criminal liability. What do you say, and why or why not, please?
I can't imagine that he would, because the way movies are set up is that somebody is in charge of these guns. I mean, again, it's a little crazy that there's even guns on movie sets. You watch any behind the scenes thing and you see all the green screens, but this 8 inches they can't take care of in post with some sort of effects. But anyways, what I'll say is this. Alec Baldwin is not in charge of that gun. He has been told it is safe. He is told it has been cleared, and he is to act as if. And so I don't think he has any criminal liability just because of the hierarchy of how these guns are hired on movies or handled on movie sets.
Right, and civil liability, a different animal. We know he has been sued, not sure how many suits, but he has been sued civilly. Jeffrey Wolf, thank you so much for being with us today. We're going to let you get going. Hope to see you back on Court TV very soon. Stuart Ryan's going to stay with us as we head into our next hour of coverage. We're going to continue watching the jury selection in the Kim Potter case. We might get a jury today. That would mean the trial is going to start a lot sooner. Thank you for watching Court TV Live, your front row seat to justice. Welcome back to Court TV Live. We have some breaking news we want to share with you now regarding the doomsday couple, Chad and Lori Daybell. Court TV is learning that a grand jury in Idaho will be reconvening in the case against the Daybells. Now, this comes as a hearing in the case is scheduled to begin within the hour here on Court TV Live. We will bring you that as soon as it begins. You'll see it all right here. But to talk a little bit about this breaking news, we want to bring in Court TV legal correspondent Gilain Painter. She's joining us now with the details. Gilain.
Hey, good afternoon, Julie. So according to multiple sources into Court TV, we are learning that the Fremont County Prosecutor's Office is reconvening a grand jury investigation into the deaths of J.J. Vallow, Tylee Ryan, and Tammy Daybell. And it will take place tomorrow, Friday, December the 3rd at the Fremont County Courthouse. And subpoenas related to the proceeding are being served on members of the community there. Now, of course, we do not know the specific purpose of this because grand jury proceedings are secret proceedings, but that is the big news coming out of Fremont County. Also today, there's a big hearing in the Doomsday Couple case at 3 o'clock Eastern. Chad Daybell will be back in court via Zoom with the judge to discuss some motions relating to his wife, and we're going to have a trial date set for both Chad and Lori.
All right. Well, we'll look forward to that. 3 p.m. Eastern time as we understand it. We know court is on a break in Minnesota in the case of Officer Kim Potter, which you're following as well here from headquarters, Gilain. Let's talk, if we can, a little bit about who is on this jury so far, please.
We have now 10 jurors seated to hear the case against Kim Potter. Today, we've seated one prospective juror, a white male in his 40s. But if we take a look back over the last couple of days, here is what the panel looks like. On Tuesday, we had day one of jury selection, and it was juror number 2 was selected, a white man in his 50s. Juror number 6, a white woman in her 60s, a retired special ed teacher. Juror number 7, a white man in his 20s, a department store manager and musician. And then juror number 11, an Asian woman in her 40s. And then yesterday we set a few more jurors. Number 17, a white woman in her 20s, a recent college graduate. Juror number 19 was also seated, a black woman, 30s, a teacher. Juror number 21, a white man in his 40s. Juror 22, a white man, 60s, private nurse. And juror number 26, an Asian woman in her 20s. And then, of course, today, if we look at overall, I believe we have juror number 40, there he is, white male, 40s, the brand new juror concerned about his personal information and safety. That's what he told this court. But he also said that he wanted to be a police officer at one time. He was actually a young police explorer. And he said that he was scared that one day he would have to use his gun, so he changed his mind and did not become a police officer. But he is the latest juror to be seated.
All right, Gilain Painter, thank you for that update. We want to bring in now trial attorney and former prosecutor Stuart Ryan. He is standing by in the Philadelphia area to talk with us a little bit more about this case. Stuart, I want to start by us watching together some of that body camera footage from Officer Kim Potter on that fateful day. We know our guest on the program the last hour who was with us, Jeffrey Wolf, was saying that he had concerns that the officers perhaps approached Daunte Wright too aggressively with the information about having that warrant. Let's listen in together to this information, to this video, if we can now. All right, now I have to say, looking at that carefully, and I'm looking for aggressive behavior by the officers, I don't see it at all. It seems that it was a very calm situation until Daunte Wright resisted the arrest. Stu, tell me what you see, please.
Yeah, I would tend to agree with you. I'd mentioned this earlier, and this is going to be, I think, I don't know about a problem for the government, but certainly a challenge. This is not Derek Chauvin. This is not a person, a police officer who's on video for 7, 8, 9 minutes, clearly acting aggressively and clearly murdering another human being, being told to stop, and not doing it. This is a bam, bam, type interaction. Now, at the same time, I think you can look at this from a different light in that you have what is clearly, or I'm going to suggest, I think probably a bad stop or a stop that's going to be looked at with questions as to why they're pulling this person over in the first place. And then also, this is the training officer. That's, I think, an important point to make. This is the person who's actually training the first officer that you see in the video, who's making the stop, who's attempting to put the handcuffs on. And I think that's important because what the government is going to be able to argue is that she's out there training on the sorts of tactics that led to the stop in the first place. Were her interactions with the victim in this case overly aggressive? No, but the things that led up to that, I think, are going to be looked at with serious suspicion on the part of anybody that might start from that place of having a little bit of suspicion with respect to law enforcement and police officers from the outset.
Mm-hmm. Right. Yeah, it'll start from the beginning, the analysis. In terms of, the plate, because I've read conflicting reports. I've read that he was stopped because of the expired tags on his car, and then I've also read that the air freshener was hanging too low and it considered an obstruction of the view, which seems like a garbage reason, quite frankly. So I'm curious to see what she says when she takes a stand in terms of why the car was stopped. So starting with that then, Stu, and then just looking at how we know it was other officers here approaching the car, right? And feel free to kind of tell us what you're seeing here as we're watching this. Kim Potter isn't even in view here. This is her body camera footage we're looking at. So she's standing a distance back.
Yeah, and from, like I said, what my understanding is that she's actually acting as the training officer for this individual police officer who's trying to cuff him. And you can kind of see she almost comes in when he's having issues trying to cuff and subdue the subject. She comes in to reach in almost as though she is teaching and training. And then this, tussle starts again, where he's trying to get into the vehicle to flee. She's saying, "I'm going to tase you." She's saying, "Taser, taser, taser." She takes her firearm and is handling her firearm. Whether that rises to the level of criminal recklessness, criminal negligence that's going to be required for the purposes of these manslaughter charges versus just, the sort of typical negligence that civil attorneys, and like myself, that's what I do now is practice in civil lawsuits representing plaintiffs. Whether that rises to that level versus criminal negligence, there is a difference. And that's going to be the real question that's going to be put to the jury.
Yeah, you're 100% right on the money with that, Stu. Whether this belongs in criminal court or in civil court or in both courts, right? Because not every homicide is a crime. And we know her attorneys are going to be arguing that this statute just doesn't fit. We had Alan Dershowitz come on the program the other day, who's arguably one of the nation's leading experts in criminal law and constitutional law, and he's saying that it's a violation of the rule of law that these prosecutors even chose to apply this because she wasn't consciously making the decision. She wasn't aware of what she was doing. And when the professor said it, it was kind of head-turning until you read the statute, and then you can understand where he's going with that. And of course, then on the other side of this, you're going to have these prosecutors who are going to be saying this was so egregious and such an embarrassment and disgrace that she didn't know that her firearm was in her hand at that time. that this does amount to recklessness and does rise to the level of the manslaughter statute. Tell me, to keep going with the analysis, this is almost like a law school analysis one would do. When you're at the point where she intercedes, and you astutely pointed out that she kind of tries to help that arrest take place of Daunte Wright when she could see her field trainee was seeming to be struggling with placing him in the handcuffs behind his back. At that point, then Daunte Wright resists arrest and he goes and he sits in his car. What I recall from serving as a prosecutor, and I'm sure you recall the same thing, is that officers are able to use force to effectuate an arrest. And so I'm thinking that where this analysis goes next, the state is going to try to make an argument that this force was excessive, and the defense is going to say, no, 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 it was totally proper. What do you think, Stu?
Well, and that's really the problem that the government is going to face, because they're going to have to come in and say that this was excessive force, and they're going to argue, well, the use of lethal force was excessive because that's the actual force that applied. But when you drill down on the issue that's going to be in front of the jury, it's not necessarily going to be what force was applied, but what force did the officer intend to apply, right? Mm-hmm. And that's where this issue of taser versus handgun comes in. And you can make your arguments about it's awful that she reached for the gun instead of the taser. How do you not know the difference between a gun and a taser on their different sides of your body, different weights, all those things. But again, she says, I'm going to tase you. She says, taser, taser, taser. As you see the car actually pull off, she releases the firearm, and you can't see her face, but you can almost hear what her facial expression is when she says, like, I shot him. And I think all of that goes to her intent. And again, the pitfalls really of what the government's arguments are going to be when it comes to use of force, because, agree or disagree, the jury's going to get instructed on the law that police officers are permitted to use a certain level of force in subduing a suspect that is fleeing. And so this is not necessarily some of the other cases that we've seen where lethal force is knowingly applied, but improperly so.
You explained that so well, Stu. So a taser, fine and good in an instance like this, arguably. We're going to have an expert in use of force coming on the program tomorrow, David Wright, and he's going to speak to that and when it's appropriate to use a taser, which is tasers are considered a less lethal weapon than a firearm versus, of course, deadly force. There is a question, I'm sure they're going to have an expert answer this, whether it would have even been appropriate to draw a firearm at that point in time. So that's going to be a big question I think we're going to see. Tell me, in terms of jurors who have experience handling firearms, I've been thinking a lot about this, Stu, and I'm not sure why, maybe because we just try to comb over everything here on Court TV, but I've been thinking, if I was trying this case on the side of the state of Minnesota and I had people in that pool who were saying they were avid shooters, love their guns, very comfortable with their guns, I think I would want them on my jury, because I think I would be able to make an effective argument that you're going to know how your gun feels. If you're a gun person, you're going to know the weight of that gun, how it feels in your hand, where you place your finger when you're ready to fire, all of that. And again, I'm no firearms expert, but just seeing what I see with the Kim Potter case, I doubt that she was an avid shooter. And why I say that is because I just think to make that dreadful mistake, I think if she was somebody that was going to the range multiple times a week with her gun, she would have, felt it, recognized that it was the wrong weapon. Tell me what you think about jurors comfortable with guns. Do you think either side may want them or not want them?
Yeah, and it's funny you mentioned her last point, especially about her familiarity with firearms, because she's a 26-year veteran, I think, of law enforcement, something along those lines. And she's already committed, at least to the court. I mean, this doesn't mean that the jury knows it, but she's committed to testifying. And when I heard that and I looked in the context of the case, I'm wondering if her lawyers have already asked you, Kim, how many times have you handled your weapon in the field? And if they're committing to her testifying, the answer very well may be never in the field, rarely in the field, and help explaining that mistake. And I also tend to agree with what you said about looking for jurors, if you're the government, who are comfortable with firearms, because firearm owners are always going to hold people who are handling firearms and potentially mishandling firearms to a much higher standard than someone who is not as familiar with whether it's firearms or really any sort of weapon. And in this sort of a situation, and jury selection is always imperfect, but in this sort of a situation, if you are representing Kim Potter and you're looking for jurors, I saw that there was one or more teachers on there. Those are the kind of people that you're looking for. You're looking for someone who is going to be more forgiving, and you hate to call this a mistake because it was fatal and unfortunately ended a person's life who didn't deserve to have their life ended, and it's a terrible tragedy. But nonetheless, as an attorney, you're looking for people who are going to be forgiving of mistakes, who are going to understand you may be trained to do something, but no one is trained perfectly, and when you're in the heat of these moments, mistakes can be made.
Excellent points, Stuart Ryan. Thank you so much for all of that. You are the perfect person to talk to when we go to our next story after this break, because you lived it. It is about comedian Bill Cosby and how Stuart Ryan's former office is petitioning the U.S. Supreme Court to overturn the ruling made by the Pennsylvania Supreme Court to vacate his aggravated indecent assault convictions. It was not about a lack of evidence. That wasn't why those convictions were vacated. He was in no way exonerated. It was a procedural issue that caused a problem. And the Montgomery County DA's office in Pennsylvania isn't letting it go without a fight. They want SCOTUS to hear the case. We'll talk to Stuart Ryan about this. He tried the case on behalf of the Commonwealth twice, convicting comedian Bill Cosby in the end of the crimes of aggravated indecent assault. We'll be right back. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. The U.S. Supreme Court could potentially hear the case involving comedian Bill Cosby, as prosecutors in Pennsylvania are asking the Supreme Court to review the ruling from the PA Supreme Court that vacated the 84-year-old's sexual assault convictions from back in 2018. What you're looking at is some footage of Bill Cosby after he was released from prison back in June. He served about 3 years. His attorneys argued that he relied on a promise that he would never be prosecuted when he gave some damaging deposition testimony in a civil case involving the same victim, Andrea Constand, back in 2006. And the statements he made that were very incriminating were later used against him in his criminal trials. Now, prosecutors in Pennsylvania say that that ruling made by the PA Supreme Court could really set a dangerous precedent if convictions are overturned over closed-door deals. This was never a formal immunity agreement that was given to Bill Cosby. It was an oral promise or a handshake deal that he wouldn't be prosecuted. He relied on it to his detriment, gave testimony, albeit with a team of lawyers representing him. He sat there, and then fast forward years later, a new DA is in town. That DA moves forward with the prosecution, brought with him a team of attorneys who did an outstanding job on the case. I saw it firsthand. I watched the first trial unfold. I was in the courtroom for it and got to see those attorneys in action. One of them is with us right now on the program. He's outstanding trial attorney, former prosecutor in Montgomery County, Stuart Ryan. Okay, Stu, so what did you think when you heard this news that they're petitioning SCOTUS to hear this thing?
Well, I thought it was the right move. As the district attorney said in the brief submitted to the Supreme Court, and as you just said, it sets a dangerous precedent. And we talked earlier about the Gilain Maxwell case, and a day or just a couple days after this Cosby decision came down, she actually cited it as a reason for her own prosecution to be dismissed. And what the district attorney's office is saying is that this concept that you can rely on a press release or the statement of a prosecutor that you are not going to be prosecuted right now to say that you are forever immunized from prosecution, regardless of how evidence may develop or new evidence may come in. That's a dangerous precedent for exactly that reason, that individuals may be able to rely on statements that are being made outside the courtroom, outside really the administration of criminal justice, just in terms of the function of the prosecutor advising the public, his or her constituents, as to what's going on about a case. That if accused individuals who become arrested criminal defendants can rely on that and say, well, I thought I would never be prosecuted, it sets, as the DA's office said, a dangerous precedent.
And I know I told you this before, Stu, but this is such an important point that's worth revisiting right now as SCOTUS could potentially hear this case. And that is what the concurring and dissenting opinion said. And now I know you read all three. There was the majority opinion vacating the convictions, one that concurred in part and dissented in part, and then a totally dissenting opinion. And the one that said, look, we agree there was a constitutional violation, but we disagree with the remedy. That's where I think this petition has some teeth, in that these justices who concurred said, look, there was a civil rights violation in using his words against him from that deposition. But the answer isn't throwing the baby out with the bathwater and putting him in a better position than he was before and saying no prosecution for you, Bill Cosby, because this happened and you relied on that immunity agreement that was never formalized. They say the remedy would be send it back to trial, but just don't allow the prosecutors to use that civil deposition testimony. Stu, so two questions for you. The first of which is, what do you think about the concurring and dissenting opinion here?
Well, so I think first and foremost, somewhat to your point, in terms of what you were laying out about the opinion itself, it also contained language that the district attorney is now relying on in terms of petitioning the Supreme Court about really rebuking the conduct of the then district attorney in terms of, if this promise was made, making it in the first place. Now, I think what you see in the concurring and dissenting opinion, as well as the majority opinion, and something that's not particularly in front of the Supreme Court right now, but does loom large in the background, is really the deference that should be, or was in this case, not shown to the trial court, in the sense that the trial court, who heard the testimony surrounding this issue, who heard the testimony of the then district attorney in 2005, who heard the testimony of the other witnesses, Cosby's own lawyers, lawyers for the victim in the case, Andrea Constand, and determined actually that there was no agreement, there was no promise, there was nothing of the sort, and made a credibility determination along those lines that the superior court, the intermediate court, then relied on, as is typical. Though the concurring dissenting opinion and the majority opinion didn't rely on that credibility and that factual determination, and even though it's not exactly in front of the Supreme Court, I do think that it looms, like I said, very large in the background of the case. And depending upon how it shakes out with the Supreme Court sending it down, whether it's a remedies issue or, an aspect of relying and showing the proper deference to the trial court, we'll just have, it'll remain to be seen.
Stu, when you and your colleagues, one of whom, of course, is the DA in Montgomery County, Kevin Steele, when you all were planning your trying of this case and the pieces of evidence you would introduce, was there ever a question as to whether or not to use that deposition testimony? Did you ever have any reluctance, I guess is what I'm asking, about using that piece of evidence? Because in my view, the Commonwealth didn't need it. You all could have proven the case without a doubt, beyond a reasonable doubt, I should say, without it.
So, and to your point, the jury said that after the conviction in the second trial, they rightly, applied the law to the facts and said, look, in this Commonwealth, the credibility of the victim is paramount. And we believe, we stand with Andrea Constand. We believe the words that she said to us, and we are unshaken by anything else we heard during the course of the trial. So in that sense, I would agree with you. Really, the case rises and falls, as sexual assault cases often do, on the credibility and the testimony of the victim in the case. As it relates to using the deposition or not using the deposition, what we were relying on in those circumstances was the trial court's decision that there had in fact not been any sort of promise or quid pro quo or anything along those lines made between the then district attorney and Cosby, such that he made that credibility determination and permitted the use of the deposition. So it wasn't so much a question about whether to use it or not, because there had been that credibility determination made by the trial judge who sat through the evidence, heard the then district attorney testify, determined, like I said, that it was not credible testimony. And so that was really what we were relying on, less so than whether we needed it at the end of the day or not. And like I said before, we believed in Andrea, and that's really what mattered.
Right. No, absolutely. The Commonwealth did not need it. Andrea Constand was such a believable, authentic witness. And I want to make sure I'm clear on something, too, for everyone wondering. The former DA, his name is Bruce Castor, and we've seen him here on Court TV as he represented former President Donald Trump in his second impeachment trial. So if that name's familiar, it may be from that our viewers might recognize the name. Tell me, were you saying that he came before the trial judge in the Cosby case in one of the pretrial hearings to decide whether or not to suppress this evidence and gave testimony about it?
Yeah, he did. It was actually the very first hearing that was in the case. Cosby was arrested in, I believe, December. And then there was a hearing in, I think, the very beginning of February of the following calendar year, but just a couple months after that. The defense filed a motion saying that, look, this case should be dismissed. It shouldn't be heard because there had been this promise, this agreement, and it had taken different forms depending upon which version of the account of Mr. Castor you were looking at. And all of that information, that evidence was presented to Judge Stephen O'Neill, who was the trial court judge. There was extensive direct testimony. There was extensive cross-examination. And what the judge did in that instance was make a credibility determination and state that he found that there was no such promise or agreement that had ever been made. And it was merely an exercise of prosecutorial discretion, meaning that the district attorney at that time decided, look, based on the evidence, in my opinion, we're not going to prosecute this case right now, but it didn't act as anything binding on any future prosecutors. As is often the case, new evidence arises, comes to the attention of law enforcement, investigations are made anew.
Sure. And Stu, and from what I understand, please correct me if I'm wrong, but just, what I've heard from some of the previous reporting that I had done on this case, and we're going back, many years, I believe December of 2015 was when those charges were filed, just in the nick of time before the statute of limitations expired. Kevin Steele was the newly elected DA. He had largely ran on that promise to prosecute Bill Cosby, as he served for years and years in your former office as an ADA in different units of the office. And it's my understanding that many people in your former office, at the time this incident occurred, going back to 2004, I believe, if I'm right on the year, many at the time believed there was plenty of evidence to move forward with the prosecution and didn't agree with the ultimate decision that Bruce Castor made as the head of the office to say, no, we're not going forward now.
Well, yeah, let me be clear. Kevin Steele actually didn't authorize the charges to be filed against the criminal defendant in this case. It was actually his predecessor. And if you're interested, you can go and look at the criminal complaint. I'm sure you saw plenty of those back in your days as a prosecutor. And right there on the front page is the signature of District Attorney Risa Vetri Furman, who authorized the filing of that complaint. And I say that because she was actually the individual tasked in 2005 with being the primary point person on the investigation, on the day-to-day aspects of the investigation. And look, she didn't have the authority at that time. She was the first assistant, the second in command. It wasn't her decision to make. It did fall to the district attorney. I do remember a point during trial that was raised with actually the lead detective from the local police department. It kind of goes to the question you had, which is where did things stand? And they had actually, the detectives investigating the case, both from the county and from the local police department, had actually had an extensive meeting the day that charges were decided to be declined by way of this press release, had an extensive meeting about the different steps that they needed to take. They had actually written down a rather substantial list of steps that they were going to take to further gather evidence in the case. That was retained in the police file. We used it as a piece of evidence at trial. And then just hours after that meeting, to the surprise of some of those detectives, the decision was made not to prosecute.
Wow. So, Stu, to be clear, and I've heard that name before, I believe you said Risa Vetri, is that correct?
Risa Vetri Furman. Yep.
Wasn't she the head of the sex assault unit? Was she a deputy DA for some time in your former office? Because I know I've heard her name. Correct me if I'm wrong here. Was she not someone who always from the outset wanted to proceed with charges against Bill Cosby?
I can't speak for then DA Furman, now Judge Furman. I worked for her. She hired me. I know the sort of credentials she brings to these sorts of cases. Certainly, she would be able to speak to whether or not she, from the outset, wanted to do this. I would imagine that the way she looked at it was like she looked at other cases, which is, okay, we have a complaint. Let's go through the investigation. Let's gather the evidence. What I do know is that she, to say seasoned, which was a seasoned sex assault prosecutor, would be a tremendous understatement. She was groundbreaking in terms of her work, not just in sexual assault cases generally, but for the children of Montgomery County, founding the first child advocacy center where children victims of sexual assault can come forward. And so she had those bona fides, so to speak, when it relates to these sorts of cases. And then she was the one that ultimately authorized the charges in 2015.
Mm-hmm. And when you said she lacked the authority before, what changed between that time and then the time when she did authorize the filing?
At the time in 2005, when she was the primary investigator from the district attorney's office, she was the first assistant district attorney, meaning she was the second in command. While she could certainly give advice to the elected DA, it's the choice and decision of the elected district attorney as to whether or not someone is charged with a crime. And in this case, the then elected district attorney, Mr. Castor, decided not to pursue charges. And then when it came to be her turn, then DA Risa Vetri Furman, based on an evaluation of the evidence, determined that that charges, were warranted, and then authorized the filing of those charges.
Gotcha. Stuart Ryan, this is all so fascinating. I'm sure we're going to continue these conversations more and more as the weeks roll on here with this big news. This is big breaking news this week, and we'll see what happens. But thank you for sharing all of that information from your experiences working on this case. I'm being told we're going to squeeze in a break as we're at the bottom of the hour, and we expect things to be getting back underway in just a matter of minutes in Minnesota with the jury selection in the Kim Potter trial. We know she's accused of the crimes of manslaughter for the shooting death of Daunte Wright when she mistook her firearm for her taser. And we have 10 jurors seated so far. Will we get the jury this afternoon? Stay with Court TV to find out. Welcome back to Court TV Live. I'm Julie Grant. The teenager suspected in a Michigan school shooting made his first appearance in court on Wednesday. 15-year-old Ethan Crumley has been charged as an adult with terrorism, causing death, and 4 counts of first-degree murder, along with several other criminal charges. Now, the community there is in shock, grieving, of course, the loss of those student victims. Police say they have evidence showing that the suspect had a premeditation in the case. He planned, they say, to carry out the shooting at his school. They also say they have mountains of evidence to support their claim. Peter Maxwell with our affiliate WXYZ reports.
Detectives and prosecutors say they have a mountain of digital evidence, including 2 chilling cell phone videos and a journal. Silent and wearing a suicide smock, 15-year-old Ethan Crumley accused of shooting and killing 4 classmates and injuring 7 others at Oxford High School on Tuesday. He's facing 24 charges, including 4 for first-degree murder and 1 terrorism charge. During his virtual arraignment, Crumley appeared on video along with his parents. The county sheriff says right now neither are cooperating with investigators.
Regardless of what the parents or the individual suspect does, our investigators are well on the path to create a very, very good case to hand the baton to the prosecutor.
Our cameras were rolling during a search of the suspect's home on Tuesday night as federal agents and local police removed evidence. Authorities removing a number of items, including 2 chilling videos from his cell phone, where Crumley talked about shooting and killing his classmates the next day at Oxford High School.
Further, a journal was recovered from Ethan's backpack, also detailing his desire to shoot up the school, to include murdering students.
Oakland County Prosecutor Karen McDonald watched the security video from inside the school the day of the shooting. Crumley armed with a handgun and armed with intent.
I am absolutely sure, after reviewing the evidence, that it isn't even a close call. It was absolutely premeditated.
Sheriff Bouchard revealing Crumley had no criminal or disciplinary record and was not on their radar. But teachers at the high school became worried about his behavior the day before and the day of the shooting. School administrators even calling his parents to the school hours before the shooting.
They brought him down to the office and in conjunction with school personnel called his parents to the school and talked about that behavior. But after that, the child was dismissed back into the school and the parents left the building.
The sheriff's office and the school district not commenting on what was said during that school meeting and the behavior that led up to that school meeting where the parents were called in hours before the shooting, and the prosecutor's office still not ruling out charges against the parents. Reporting in Oxford Township, I'm Peter Maxwell.
Now we want to take a look together at a portion of Crumley's first court appearance. This was done via Zoom. Here's how it all played out.
Sir, do you understand all the charges against you?
Yes, I do.
Again, you have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand your right to remain silent?
Yes.
You also have, of course, your right to an attorney, and Mr. Kozak and Ms. Hatton have been with you, and that right will continue throughout all legal proceedings. And as it relates to anything further, we do need to set a bond. As it relates to bond, I will first let actually we do have pretrial services here to make a recommendation as to bond, and then we will let each attorney speak as it relates to that. So if the individual from pretrial services can come forward, state their full name and spell it for our court recorder.
Darla Finley, pretrial services.
I'm sorry, Judge. Just before we do that, I just want to make sure it's clear that my client is standing mute. We're asking the court to enter not guilty.
I'm sorry. Yes. I will enter a plea of not guilty on his behalf, and we will set this for bond. Thank you, Mr. Kozak.
Darla Finley, pretrial services, DARLA FINLEY. The defendant was unable to be interviewed due to his location at the Children's Village. Therefore, that we have limited information. We do know that he's 15 years old, a resident of Oxford. He's a sophomore at Oxford High School. He has no prior juvenile record, no noted police contacts in Clemens. Given the serious nature of the matter, there's no conditions or combinations of conditions which will assure the defendant's appearance in court or safety to the community at large. Therefore, we recommend that bond be denied.
Thank you from pretrial services. Mr. Keast, anything you'd like to state?
I would, Judge, thank you. Because the defendant is a juvenile charged as an adult, this court must look at Michigan Court Rule 6.909, subparagraph 2. That court rule states that regarding detention without bail, if the proof is evident or that the presumption is great that the juvenile committed the offense, the magistrate or the court may deny bail, subparagraph A, to a juvenile charged with first-degree murder. Judge, in this case, I am asking this court to deny bail as pretrial supervision has indicated. As a offer of proof, I think it's appropriate for this court to have a brief chronology of what happened on November the 30th, 2021. As you heard during the swear-to, Judge, Oxford High School is equipped with surveillance video. We've had the opportunity to review that surveillance video just this morning. And what's depicted on that video, honestly, Judge, I don't have the words to describe how horrific that happened on November the 30th. It depicted just before 12:51 p.m., this defendant entering a bathroom with a backpack. A minute or two later, he exited the same bathroom without the backpack, but with a gun in hand. At that point, he methodically and deliberately walked down the hallway, aiming the firearm at students and firing. Right outside the bathroom, he began firing, Judge. After children started running away from the defendant, he continued down the hallway, again at a deliberate and methodical pace, pointing and aiming inside classrooms and at students who hadn't had the opportunity to escape. This continued on for approximately 5 minutes. The defendant went to another bathroom. As deputies arrived, he set the firearm down and he surrendered. Judge, a preliminary review of the defendant's social media accounts, his cell phone, as well as other document evidence recovered on scene showed that this defendant planned this shooting. He deliberately brought the handgun that day with the intent to murder as many students as he could. Judge, I believe no bond is appropriate. And again, like I stated, at the appropriate time, I'd like to make a motion to transfer this defendant from Children's Village to the Oakland County Jail.
Thank you. Mr. Kosak?
Your Honor, understanding the extreme nature of this case and understanding the circumstances at hand, and having spoken to Mr. Crumley as well as his parents, I'm going to leave the setting of the bond in the discretion of the court.
Thank you. Anything further from Ms. Hatton?
Nothing further, Your Honor. I leave in the discretion of the court.
Thank you. And I'm assuming you don't want your client to speak.
That's correct, Your Honor, on both Mr. Kozak and my behalf.
Thank you. I do believe, based upon all the information that's been provided to date, that a no bond, a denial of bond is appropriate pursuant to court rule, and I will order no bond on this case.
No bond, certainly appropriate for him. We're going to squeeze in a break. When we come back, we'll take you to Minnesota as jury selection is picking back up for the trial of former officer Kim Potter. We want to return now to Minneapolis, Minnesota for more of the jury selection in the trial of former officer Kim Potter. Let's go in together live as the judge is back from the lunch break.
Of Daunte Demetrius Wright while committing the misdemeanor offense of reckless handling or use of a firearm so as to endanger the safety of another with such force and violence that death or great bodily harm to any person was reasonably foreseeable. Count 2 is for second-degree manslaughter, and that count alleges that on or about April 11, 2021, in Brooklyn Center, Hennepin County, Minnesota, defendant Kimberly Ann Potter caused the death of Daunte Demetrius Wright by her culpable negligence, whereby Kimberly Potter created an unreasonable risk and consciously took a chance of causing death or great bodily harm to Daunte Demetrius Wright while using or possessing a firearm. The defendant has pleaded not guilty. This plea denies the charges made against her and places upon the state of Minnesota the burden of proving her guilty beyond a reasonable doubt. The state is represented by Attorney General Keith Ellison, Mr. Matt Frank, Ms. Erin Eldridge, and Mr. Josh Larson. The defendant is represented by Mr. Earl Gray, Mr. Paul Ing, and Ms. Amanda Montgomery. I do want to introduce to you a couple of people that will play critical roles in this case. You've probably already met my staff. My law clerk is Mr. Zach Kramer, and my judicial clerk is Ms. Jessica Bauer. They'll be taking care of all administrative matters relating to these proceedings, and if any problem arises of a personal nature, please let my staff know, and they'll get the message to me. Seated in front of me is Ms. Carly Davis. She is a certified court reporter, and she's responsible for taking down all the testimony and keeping a formal record of the trial. That means when you respond to questions, you must speak loudly and clearly so that our court reporter can make an accurate record. If your answer is a yes or a no, you must answer orally instead of shaking your head because we can't make a record of that. And please refrain from saying uh-huh and although it's kind of natural to do that. Okay, a couple of things before we start the jury selection. First of all of you are required to keep your masks on at all times. I will allow you to remove your mask when you're in the witness box being asked questions, but the attorneys are required to wear their masks as well unless they're at the podium that's enclosed by plexiglass. Let me give you an overview of what jury selection is going to look like. First of all, I'm going to ask you group questions. There is no need for you to answer orally. It's just a matter of raising your hand or not raising your hand in response to my questions. Then there will be an individual part of the jury selection. And what will happen there is I'll take each juror at a time, dismiss the other jurors, and have them wait in the courtroom that's set up for you. And you'll be seated in the witness box, and I'll ask you to remove your mask. During the individual questioning, I'm just going to do some follow-up questions to the answers.
Voir dire will be rolling on. We have to roll to a break. Before that, we want to give you a little reminder that this afternoon, shortly, we're going to be seeing a hearing held for the doomsday couple, Chad and Lori Daybell. We're going to bring that to you live. We know that defense attorneys for Chad Daybell have filed a motion for some discovery concerning a recent event with Lori Daybell and an attorney with the Church of Latter-day Saints. An official trial date is also expected to be set for a joint trial for these co-defendants. That hearing set to happen at 3 p.m. Eastern Time. Again, you can see it all live right here on Court TV.